Hi, welcome back to Space Thoughts. I just wanted to do this quick video regarding a ruling by the FCC on SpaceX Starlink satellite mega constellation. Now, what happened was basically SpaceX wants to lower the operating altitude of its of the Starlink mega constellation from where it is now to a lower altitude in LEO. And I'm not going to go into the details of exactly what they're requesting. But there's been a lot of pushback from a lot of satellite companies like Vivisat and Dish Network, and there's also been pushback by non-governmental organizations as well. Vivisat in particular raised an argument in opposition to this idea of lowering this mega constellation, invoking what's called the National Environmental Protection Act, or NEPA for short. Now, basically, to make it quick and short, NEPA was a environmental law that was implemented back in, I believe, 1970, and fundamentally it says for any significant federal action there has to be an environmental review to see what effects, if any, there's going to be on the human environment. Now, back in January there was an article in Scientific American talking about an article by a law student that basically says that the FCC has violated NEPA by not doing an environmental assessment of the Starlink satellite constellation. And I didn't see the article beforehand, but I just from what I read from the actual article itself, I kind of did an analysis for my briefing letter, the press. I did a special issue, and I think it was back in February of 2020, and I basically dissected the argument that NEPA applies. Now, I'm not going to go into why NEPA doesn't apply, in my opinion, from a legal standpoint, but rather I'm just going to talk about, the FCC's rationale for not applying NEPA in this case, which they actually talk about in this opinion, which we're going to in a moment. Now, again, saying, well, we'd like to see that. If you'd like to see that actual opinion, if you are a subscriber to my briefing letter, send me an email or contact me somehow and let me know that you're a subscriber and you'd like a copy of that special issue, and I'll send it along to you. If you're not a subscriber to my briefing letter, well, I'm going to ask if you want to get that. I would welcome you as a subscriber, and once you do become one, I'd be happy to send you a copy of that briefing letter and my opinion as well. So without further ado, we're going to go over to the opinion. And again, I'm not going to really dissect this opinion because it's over 50 pages and it's very dense, as most of these FCC opinions and orders are. But I wanted to address specifically the National Environmental Policy Act in particular, or how the FCC approaches it. Now, the FCC has always held that satellites are categorically excluded from any type of environmental assessment. They don't think there's anything necessary. There really isn't necessary to do it. And some of that rationale is right here in these paragraphs here, in paragraph 72 and 73 in particular. And fundamentally what it says, the Commission's rule provide that except for a specifically enumerated list of conditions that expressly require the preparation of an environmental assessment, other than what is known as an EA, other Commission actions are deemed individually and cumulatively to have no significant effect on the quality of the human environment and are categorically excluded. In other words, the argument that the FCC is making is that these satellites in particular don't have an effect on the human environment on Earth, and therefore they're categorically excluded from an environmental assessment, as far as the responsibility of the FCC to either perform one or request that an EA be performed by a licensee, an applicant for a space station. And space station is basically the nomenclature that the FCC uses for satellites. Under the Commission's rule, the Commission has delegated to its licensees and applicants both the initial assessment of whether a deployment is categorically excluded from further environmental review and the preparation of an EA when required. Applicants must determine whether a proposed action falls under one of the specified categories in the FCC rule that would require an EA. In other words, it isn't always up to the FCC. The FCC will basically say whether or not an EA is necessary, but it's left up to the applicant to actually perform it, and at the expense of the applicant. And this is basically what Vivisat is saying, or said in an argument that it made to the FCC a few months back, is that the FCC should have required an environmental assessment about the effect of these mega constellations, or the Starlink constellation in particular, before it actually granted a license, or even before it granted the authority to lower the altitude of these satellites. Given that category set forth in section 1.1307A and B of the FCC rules largely focus on environmental effects, I'm going to scroll down here. At the Earth's surfaces, space stations generally have not triggered these categories and therefore have been categorically excluded from review. So in other words, the FCC is saying we basically excluded space stations, satellites, what have you, from the NEPA requirement because they don't affect the surface of the Earth, or what's called the human environment. And if you really want to get an understanding of NEPA, I'm not going to go into NEPA in this video because it's really drawn out and complex. But if you want to understand NEPA, the term human environment is important. The idea is whether a federal action, in other words, in this case, the FCC granting the license for the Starlink and GSO, affects the human environment, particularly at the surface of the Earth. And the FCC has basically categorically excluded NEPA, saying these satellites, by deploying them, don't really affect the human environment. Paragraph 73, the Commission's rules also state that even if an action is otherwise categorically excluded, an interested person who alleges that the action will have a significant environmental impact shall submit a written petition setting forth in detail the reasons justifying or circumstances necessitating environmental consideration in the decision-making progress. Under that provision, the Bureau responsible for the particular action shall review the petition and consider the environmental concerns that have been raised, and if the Bureau determines that the action may have a significant environmental impact, the Bureau will require the applicant to prepare an EA, which will serve as a basis for the determination to proceed with or terminate environmental processing. The Commission has not typically received petitions raising environmental concerns regarding the licensing of space stations. So Vivisat basically set forth some an argument in a filing that of why the FCC should require an environmental impact statement. And one of them had to do with light pollution and then space debris. And another one was called on a really innocuous preliminary study that basically that called into question the effect of multiple, large numbers of satellites re-entering the Earth's atmosphere, what the cumulative effect that would have on the Earth's atmosphere and climate change. And apparently the argument was really, I looked at the argument and basically said, well, this really is just throwing mud at the wall to see if it sticks. And apparently the FCC doesn't think the mud sticked because it's basically decided that an environmental impact statement isn't necessary. So what I want to get through to you in this short video is fundamentally that NEPA is really being pushed. And a lot of that, I think, was precipitated by that article by that law student. And it's being used as a tool, I think, and a competitive tool, if you will, to defeat these, to fight back against these mega constellations. Now, the question is, well, we got to consider the environment of our space, and I agree with that completely. But I don't think NEPA is really the tool for it. I mean, you've got to have the right tools for the job, and I've always, and my biggest complaint is people tending to take Earth-based rules and Earth-based environment and try and compare it to outer space, whether it's making policy or making space law. Outer space is really its own unique environment, and we got to have different laws. In my opinion, taking basically it's comparing. I have a screw that I got to put in, but I have a socket wrench that I'm trying to do it with. I don't have the right tool for the job, and this is kind of the case here. People want to address any environmental concerns, but they want to use a tool that was designed back in the 70s that really didn't foresee this whole idea of commercialization of outer space and try and apply it to that. In other words, they want to use the socket wrench to put the screw in, the screw being these satellite constellations, and it just doesn't work. I mean, the real answer is we got to make new laws, and that's up to Congress. And unfortunately, Congress has been more occupied with politics now than it really has been in looking at outer space and really making some solid rules. So my admonition is basically, okay, you want these, instead of lobbying to use these rules that are really Earth-based, these environmental laws that are Earth-based, make new rules if you think it's necessary. If it's really important, make new laws, get them passed and get them implemented. In other words, give the agencies that do licensing, Give them new tools so that they can implement these things. I think my biggest concern with NEPA has been fundamentally that if you start applying NEPA to satellites in low Earth orbit, eventually somebody's going to try and stick it onto satellites in medium range orbit, or MEO, and eventually geosynchronous orbit, and then we're going to get to the moon, and then we're going to get to celestial bodies, then we're going to get to cislunar space, and then we're going to get to interplanetary outer space. In other words, the whole idea is if you start using this tool, using this law for outer space in one context, it's going to eventually spread to other contexts of space development and exploration. So really, fundamentally, NEPA is a terrestrial law. It's not an outer space law. And once you break through that ceiling of applying it to something that was never intended to be applied to, the sky's the limit. No pun intended. I mean, where it actually gets used or abused. Whether this will go into litigation, I don't know. It depends. These companies who are fighting that back against mega constellations like Starlink might find it useful to go into court and get a ruling that NEPA does apply to NGSOs. I mean, Personally, I have a legal argument against that, and if you read that special issue of my briefing letter to Pressy, I mean, you'll understand my rationale for doing so, and I think it's a pretty solid legal analysis and legal position. But fundamentally, my point is NEPA doesn't belong in outer space. I think the FCC did a good thing by pushing back hard on this and quashing it in this instance, and if we really want to address, the outer space environment, we're going to have to make new laws. We're going to have to craft new laws. And at this, especially once we start developing the moon and cislunar space, we're going to have new laws to address, environmental impacts, because the environment is important. But we got to have the proper tools to do it, and not use tools that are decades old, that were never created to address outer space matters. So that's all I have for this video. I'll talk to you next time.